I want you to hold this image in your mind. A woman in active labor, contractions 4 minutes apart, hospital bag by the front door, car keys in her husband's hand, and a knock at that door. Not the neighbor, not the midwife, not anyone he has come to help with the extraordinary, terrifying, beautiful thing that is about to happen in the next several hours. An attorney, in a gray suit, with a manila envelope. My husband Derek opened the door. He looked at the attorney, he looked at the envelope, he looked at me, standing in the hallway in the specific posture of a woman whose body is doing something enormous, and who needs more than she has ever needed anything, to get in the car and go to the hospital. And he stepped aside to let the attorney in. I want you to hold that image, Derek stepping aside, because it is the image I came back to over and over during the 14 months that followed. Not the eviction papers, not the contractions, not even the attorney's voice reading the legal description of the property I was being removed from. Derek stepping aside. That was the moment I understood what I was dealing with. That was the moment the tactical part of my brain, the part that had served me through 12 years as a contracts paralegal, the part that had read thousands of legal documents and knew what words in what order meant what, went very quiet and very cold and began paying attention in a different way than it had been paying attention 60 seconds earlier. I did not sign anything. I want to say that clearly right now before the rest of the story. I did not sign anything that day. I looked at the attorney. I looked at Derek. I looked back at the attorney. I said, I am in active labor. I am not signing any document today. Get out of my house. And then I picked up my own hospital bag, walked past my husband, past the attorney in the gray suit, out my own front door, and called my sister from the driveway to drive me to the hospital. My daughter was born 4 hours later, and 14 months after that, in a courtroom in Asheville, North Carolina, a judge read one line from a deed document aloud, a line that the Marsh family's attorneys had reviewed and missed, that Derek had never known existed, that his father Richard had apparently believed was irrelevant. And my mother-in-law Patricia Marsh grabbed the edge of the defense table with both hands, the way a person grabs something when the floor moves beneath them. This is the story of that line, and everything that led to it. Part 1, The Betrayal. My name is Caroline Marsh, legally still, because I have not yet finalized the divorce, and because I have specific reasons for maintaining that name through the end of the legal proceedings that I will explain. I am 38 years old, and I grew up in Hendersonville, North Carolina, the daughter of a general contractor named Bill Sutton and a woman named Joyce who taught 3rd grade for 31 years and had the specific unshakable calm of someone who has managed 23 8-year-olds at a time and knows that most crises are survivable. I studied paralegal studies at AB Tech in Asheville, then spent 12 years at a mid-sized real estate law firm, Hensley & Pruitt, where I became the kind of contracts paralegal that attorneys bring their most complicated documents to. Not because they couldn't read them themselves, but because they knew I would find the thing they missed. I met Derek Marsh at a mutual friend's wedding in 2015. He was 32, an architect with a small firm in Asheville, good-looking in an understated way, and possessed of an ease around people that I found appealing in the way you find appealing the quality you yourself lack. I was methodical and precise, and somewhat interior. Derek was social and warm, and moved through rooms with a confidence that didn't announce itself. We dated for 2 years. We moved in together. We got engaged. I want to tell you honestly that I was happy during those years. Not blindly happy. I had noticed things, the way you notice things about a person when you're paying attention, which I always was. I had noticed that Derek deferred to his father Richard in ways that occasionally struck me as more than filial respect. I had noticed that Patricia, his mother, asked certain questions with a frequency and a specificity that suggested active monitoring rather than casual interest. I had noticed that when family decisions conflicted with couple decisions, the family decisions tended to win. But these are the things you notice and file and tell yourself are manageable because you love someone, and love has a way of making the manageable seem important and the important seem manageable. We married in September of 2018. The house on Ridgeline Drive in Asheville, a 3-bedroom craftsman on a half-acre with a view of the mountains that made your chest open every time you stood on the back porch, had been purchased in 2017 before the wedding with a combination of Derek's savings and a down payment gift from Richard and Patricia Marsh. The down payment gift was $60,000. Richard Marsh was a property developer in western North Carolina, a man who had spent 40 years buying land cheap and building on it and selling it profitable, and who thought about real estate the way other men thought about chess. Always several moves ahead, always with a strategy that the other players hadn't been shown. When Richard gave Derek $60,000 toward the house, he did it through a mechanism that I, a contracts paralegal who reviewed real estate documents for a living, should have examined more carefully. I did not examine it more carefully, because it was a gift from a father to a son, and because I was in love, and because the house was beautiful, and because examining your future in-laws' gift money with professional skepticism felt, at the time, like something only a suspicious and uncharitable person would do. This is the professional failure I have made my peace with. Richard's gift came with what his own attorney described, in the accompanying paperwork, as a deed of gift with retained interest clause. Standard language, the attorney had explained at the time, simply confirming that the gift was conditional on the property remaining within the family and would need to be repaid if the property was sold to a third party within 10 years. Standard language, a protection for the parent's gift. Completely reasonable. Derek and I had signed the accompanying paperwork without significant discussion. I remember skimming it. I remember the attorney, Richard's attorney, a man named Clifton Webb, who I now understand was fully aware of every word of every document he had ever produced for Richard Marsh, describing the retained interest clause in approximately 45 seconds and moving on. I filed it in the way you file things that seem routine. The house was titled in Derek's name, not in both our names, in Derek's name alone, because the down payment gift had been structured through Derek, and the mortgage, though applied for jointly, had ultimately been underwritten in Derek's name alone, due to a credit complexity on my end, at the time of application, that had made joint titling procedurally cumbersome. I had not pushed the joint titling question. I was a paralegal. I knew that in a marriage, property acquired during the marriage was marital property, regardless of whose name held the title, in North Carolina as in most states. That was the second professional failure I have made my peace with. Derek and I married, moved into the house, and spent 4 years building what I believed was a life. He had his practice. I had my firm. We were not perfect. No couple is perfect, but we were functional and affectionate and pointed in the same direction, or so I believed. The direction changed somewhere in 2021. I can look back now and identify the specific month, March, when Richard's development company ran into a significant financial problem related to a failed commercial project in Buncombe County. But at the time, I experienced it as a gradual atmospheric shift. Derek was more distracted. He went to his parents' house more frequently. He took calls from his father at dinner and stepped outside for long conversations that he summarized afterward in brief, uninformative sentences. I became pregnant in February of 2022. The pregnancy should have been, and in many ways was, a happy development. Derek was warm about it. Genuinely, I believe. He was going to be a good father. That is a thing I have had to hold alongside everything else, because the truth is complicated, and Derek is not a cartoon villain. He was a man who had never fully separated himself from his family's gravity, and when that gravity pulled hard enough, he went with it, rather than staying where he'd chosen to be. In August of 2022, 2 months before my due date, I began to notice something. Derek was spending more time with his father. Specific conversations that stopped when I entered rooms. A tension in his body when I asked about the house finances, the mortgage, the property tax account, the insurance renewal. I asked him directly in September, "Is something going on with the house?" He said, "Everything's fine." He said it in the voice of a man who has been coached on what to say. I made a note. A paralegal's note. Not dramatic, not accusatory, just the professional habit of documenting the thing that doesn't match. My due date was October 14th. On October 9th, 5 days early, at 6:45 in the morning, my labor began. At 7:23 a.m., the attorney knocked on the door. Part 2. The Fall. My sister Renee drove me to Mission Hospital in Asheville. She did not ask questions during the drive. She is 3 years older than me and a labor and delivery nurse, and she understood that the next several hours required her in one mode only: present, calm, and focused on the immediate biological priority. My daughter Hazel was born at 11:51 a.m. on October 9th, 2022. She weighed 7 pounds, 4 ounces. She had my mother Joyce's eyes, and what I would later decide was nobody's nose from either family, which I considered an encouraging sign of independence. Derek arrived at the hospital at 1:15 p.m. He had not been there for the birth. I want to be precise about what happened when he came into the room, because it matters for understanding everything that came after. He looked at Hazel. Something crossed his face that was real, the involuntary response of a man seeing his child for the first time, which cannot be entirely manufactured, regardless of what else is happening. He reached out and touched her hand. Then he looked at me. Caroline, he said, I need to explain. Not now, I said. Not now, I said again. My voice was entirely level. Renee, standing on the other side of the bed, gave Derek a look that conveyed, without words, that this was not the moment, and that there would be significant personal consequences for him if he attempted to make it the moment. He sat in the chair in the corner. He did not try to explain again that day. The hospital stay was 2 days. On the second day, my parents arrived. My father Bill and my mother Joyce. And my father shook Derek's hand with the specific grip of a man who has not yet decided whether to use it to hurt someone, and who is maintaining his options. My mother held Hazel and said nothing to Derek at all, which from Joyce Sutton was louder than most people's speeches. I went home from the hospital to my parents' house in Hendersonville, not to Ridgeline Drive. I had nowhere else to go. The eviction papers, which Renee had photographed on my behalf before the attorney left the house that morning, with the professional foresight of a woman who has a paralegal for a sister, named me as an occupant without legal standing to remain in the property. The papers had been filed in Buncombe County District Court under Derek's name as the property owner, removing me as a cohabitant. I had not been named on the deed. Under North Carolina law, an eviction proceeding against a non-titled spouse during an ongoing marriage was a legal complexity that the Marsh family's attorney had apparently decided to test. It was not a clean case. A married woman has significant rights in marital property, regardless of title. But it was, as a tactical move, designed to displace me immediately and leave the legal argument for later, after I was already out of the house and managing a newborn from a temporary situation. Displacement first, legal argument second. Richard Marsh had spent 40 years in property development. He understood that possession was not merely 9/10 of the law. It was, practically speaking, the whole game. What Richard had not accounted for was that his daughter-in-law was a contracts paralegal who had spent 12 years reading documents that people had hoped she wouldn't read carefully, and that she had 2 days in a hospital room with nothing to do but think, and that she had photographed every page of the eviction filing before she left the house. I lay in that hospital bed the second night, with Hazel asleep on my chest, and my sister asleep in the recliner, and the photograph of the eviction filing open on my phone, and I read every word. On the third page, in the section describing the legal basis for Derek's sole ownership of the property, there was a reference number. The deed recorded in Buncombe County Register of Deeds, Book 4471, page 238. I knew that number, not because I had memorized it, because I had encountered it once, briefly, in the paperwork surrounding the down payment gift in 2017, the deed of gift with retained interest clause. I put my phone down. I looked at the ceiling of the hospital room. I thought about what I knew about deed restrictions in North Carolina real estate law. I thought about what a retained interest clause could mean in a document drafted by Richard Marsh's attorney for a transaction designed by Richard Marsh, involving a property that Richard Marsh had put $60,000 into. I thought about all the things Richard was: patient, strategic, always several moves ahead, always with something in the documentation that protected him. And I thought, what if the protection he built into that document protects me too? What if he was so focused on protecting himself from a sale to a third party that he didn't think about what else that clause might do? I picked my phone back up. I opened the Notes app. Part 3, Discovery. I spent the first 2 weeks after Hazel's birth at my parents' house, healing and nursing and sleeping in 4-hour increments, and whenever Hazel was asleep and my body allowed it, working. My mother Joyce brought me tea and asked no questions and kept my father from hovering, which was its own kind of gift. I needed one document: the actual recorded deed, Book 4471, page 238, Buncombe County Register of Deeds. In North Carolina, recorded deeds are public documents. They are accessible online through the County Register of Deeds portal. Any person with internet access can look up any recorded deed in Buncombe County at any time. Clifton Webb, Richard Marsh's attorney, had apparently not considered this when he designed the deed of gift transaction in 2017. Or he had considered it and decided it didn't matter. He was wrong. I pulled the deed on a Tuesday morning 2 weeks after Hazel was born, sitting at my parents' kitchen table with a cup of tea I had let go cold, and my reading glasses that I only admitted to needing when I was working on something important. The deed was 4 pages. I read it the way I read every document that matters, from the beginning, every word, no skimming, no assumption about what any section contains based on what the section heading says. Page 1, Standard Property Description, Legal Description of the Parcel, Grantor and Grantee Information. Page 2, The Consideration and the Warranty Language, the Standard Provisions of a North Carolina General Warranty Deed. Page 3, The Retained Interest Clause, which I read 3 times, and which said in relevant part what Clifton Webb had described in 45 seconds 5 years earlier, that the gift was conditional on the property remaining within the Marsh family for a period of 10 years from date of transfer, and that sale to a third party within that period would trigger repayment of the gift amount to the grantor. Standard. Expected. Exactly what had been described. Page 4. Page 4 was where Clifton Webb, in my professional opinion, had made the kind of mistake that happens when an attorney drafts a document to protect one set of interests so completely that he fails to see what the document does to a different set of interests he wasn't focused on. Paragraph 7 of page 4. It was a covenant. Specifically, it was a use and occupancy covenant attached to the retained interest clause that read, and I am going to give you the relevant language because every word of it matters. The property described herein shall be maintained as the primary residence of the grantee, or the grantee's immediate family members for the duration of the retained interest period, or restrict the occupancy rights of an immediate family member of the grantee during the retained interest period shall constitute a breach of this covenant, triggering the accelerated repayment provision of Section 4B and rendering the deed transfer voidable at the grantor's election. I read that paragraph 4 times. Then I read it a 5th time. Then I put my teacup down with a steadiness that surprised me, given what was happening in my chest. Let me explain what I had found, in plain language, because the legal architecture of it is important. Richard Marsh, in designing the deed of gift, had included a use and occupancy covenant intended to ensure that the property remained a Marsh family residence for the duration of the 10-year retained interest period. The purpose of this covenant, for Richard's perspective, was almost certainly to prevent Derek from selling the house or renting it out in ways that would undermine the family's connection to the property. But the covenant used the phrase, immediate family members of the grantee. Derek was the grantee. I was his wife. In North Carolina, a spouse is an immediate family member. The covenant protected my right to occupy that property, and Derek's eviction action, filed in the very court where Richard's attorney had recorded the deed that contained this covenant, was by the plain language of paragraph 7, a breach that triggered the accelerated repayment provision, meaning if Derek evicted me, Richard's $60,000 gift became immediately due and repayable to Richard. But that was only the beginning, because the covenant also said something else, rendering the deed transfer voidable at the grantor's election. Voidable at the grantor's election. Richard Marsh had built himself a nuclear option in the original deed, designed to let him take the property back if Derek violated the covenant terms. Derek had violated the covenant terms. By evicting me, his immediate family member, Derek had handed his father the legal mechanism to void the entire deed transfer, to take the house back from Derek, to return it to Richard. The house would go back to Richard, not to Derek, not to the Marsh family's plan for what came next. To Richard. I sat at my parents' kitchen table with the deed on the screen in front of me, and the cold tea beside me, and Hazel asleep in the next room. I thought about Richard Marsh. Patient, strategic, always several moves ahead. I thought about what always several moves ahead means when the board has changed and the pieces are no longer where you thought they were. And I thought about one more thing. Richard had filed an eviction action through Derek. Richard was the grantor. The covenant gave Richard the election to void the deed, but the covenant did not require Richard to exercise that election. What happened if someone else triggered the accelerated repayment provision first? What happened if I, as the displaced immediate family member, whose occupancy rights had been breached, filed a claim based on the covenant violation before Richard had time to consider his options? What happened if Richard suddenly found himself not in control of the timeline? I called my attorney. Part 4. Preparation. I need to tell you about Helena Voss before I tell you what came next, because Helena is as important to this story as the deed. Helena Voss was a senior partner at a firm in Asheville that I had worked adjacent to, not for, but adjacent to, in the way that attorneys and paralegals in a small legal community know each other across firm lines, for 11 years. She specialized in real estate litigation and family law. And she had a reputation in the Asheville legal community that can be summarized in 3 words people used about her in varying combinations: precise, relentless, and expensive. I called her on a Wednesday morning. She answered on the second ring. Caroline Sutton, she said, using my maiden name, because Helena knew me from before the marriage and used the name she'd always used. I heard about the eviction. I was wondering when you'd call. I found something in the deed, I said. A pause. "Come in," she said, "today." I drove to Asheville with Hazel in the car seat, and the deed printed from my parents' home computer, and my legal pad with 6 pages of notes. And I sat across from Helena Voss in her office for 3 hours. Helena read the deed with the attention I had read it with, which is to say, completely. And when she reached paragraph 7 of page 4, she went still in the way that experienced attorneys go still when they have found something significant. She read it twice. Then she looked at me. "Does Richard Marsh know this is here?" she said. "I don't know," I said. "His attorney drafted it." "Clifton Webb drafted it," she said, in a tone that told me Helena and Clifton Webb had history. "Clifton is thorough about protecting his client's interests. He is less thorough about consequences." "The eviction action is a breach," I said. "Yes," she said. "Accelerated repayment triggers immediately, and the deed transfer is voidable." "Yes." She paused. "At the grantor's election." "Which is Richard," I said. "Which is Richard," she confirmed. "Which means Richard can void the deed and take the house back from Derek." She looked at me. "Which is not what you want." "No," I said. "I want to trigger the accelerated repayment provision before Richard can exercise the voiding election. I want the $60,000 called due and the covenant breach documented in court before Richard has the chance to decide what to do with the voidable deed." Helena looked at me for a long moment. "You want to get in front of him," she said. "He spent 40 years getting in front of people," I said. "I want to know what it feels like to be there first." Helena picked up a pen. "Tell me everything about the day of the eviction," she said. "Every detail, from the first contraction." When I finished, she had 2 pages of notes and an expression that I had not seen from Helena Voss in the 11 years I'd known her professionally. She looked, for the first time I could remember, genuinely delighted. "Caroline," she said, "they served you eviction papers while you were in active labor." "Yes," I said. "While your contractions were 4 minutes apart." "Yes." "With your hospital bag packed by the front door." "Yes." She set her pen down. "I'm going to need you to give me everything," she said. "Every document, every photograph, every note you made. And I'm going to need your sister's account of what she saw that morning." "She's a labor and delivery nurse," I said. "She documented everything from the moment I called her. Medical timeline, observed distress, time of eviction service, she has it all." Helena looked at me. "Renee documented it in real time," she said. "She's a nurse," I said. "She documents in real time." "What I'm going to file," she said slowly, thinking as she spoke, "is a multi-pronged action. First, a motion to void the eviction proceeding on the grounds that it constitutes a breach of the covenant in the original deed, which supersedes Derek's claimed ownership rights under the eviction statute. Second, a claim for breach of the occupancy covenant, naming both Derek and Richard as respondents, Richard as grantor of the breach deed, Derek as grantee who executed the breach. Third, a family law claim for marital property rights in the home as a marital asset, regardless of title. 3 fronts, I said. "Richard is a property developer," she said. "He understands attrition. We're going to make this expensive enough on enough fronts that settling is cheaper than fighting." She paused. "And we're going to file before he figures out what you found." "How fast?" I said. "How fast can you get me everything?" "I have it with me," she said. Helena Voss smiled. It was not a comfortable smile for the people it was aimed at. "Monday morning," she said. "We file Monday morning." Part 5, the clause. Helena filed on Monday morning. I want to describe the 48 hours that followed, because they contained the moment I had been building toward without knowing it, since the attorney knocked on my door in October. The filing landed on a Wednesday in the offices of Clifton Webb, who represented both Derek and Richard in the property matter. Helena had structured the filing specifically. The covenant breach claim naming Richard as respondent was the first document in the package, followed by the eviction void motion, followed by the marital property claim. Clifton Webb would see his own document come back at him like a boomerang. Helena told me later what her contact at the courthouse clerk's office described. Clifton Webb had come to the clerk's office personally to obtain copies of the filing, unusual for an attorney of his tenure who typically sent a paralegal, and had stood at the counter reading the covenant breach claim with an expression that the clerk described as a man discovering a leak in the roof of a house he'd just told someone was watertight. Richard Marsh called Derek that evening. Derek called me. It was the first time we had spoken since the hospital. "My father wants to know where you got a copy of the deed," Derek said. His voice was careful, in a way that told me he had been instructed on what to ask. "It's a public record," I said. "Book 4471, page 238, Buncombe County Register of Deeds. Anyone with internet access can pull it. Silence. He didn't know you'd read it, Derek said. I'm a contracts paralegal, Derek, I said. I read things. Another silence. He's very upset, Derek said. I imagine he is, I said. He wants to talk about a resolution. He can talk to Helena Voss, I said. That's what she's there for. I ended the call. I sat in my parents' living room with Hazel in my arms, and I felt something that was not triumph. Triumph is loud, and what I felt was quiet, but was something adjacent to it. The specific satisfaction of a person who has been told the room they're in has no exits, and who has found the door that was always there, behind the thing nobody thought to move. The preliminary hearing was scheduled for 3 weeks after the filing. I want to describe the courtroom, because rooms matter in this story. Buncombe County District Court, Courtroom 7, on a Thursday morning in January of 2023. Wood paneling, fluorescent lights that hummed at a frequency just below conscious annoyance. The specific smell of a room where important things happen routinely, which is the smell of paper and coffee and the accumulated weight of other people's difficult days. Judge Causey was 63, with 30 years on the bench, and she had the particular quality of experienced family law judges. She had seen everything and was surprised by nothing, and had a face that gave away less information than a professional poker player. Richard Marsh sat at the defense table beside Derek. This was unusual. Richard was not a party to the eviction proceeding, only to the covenant breach claim. But he had insisted on being present, and Clifton Webb had allowed it, perhaps because Richard had never in 40 years of property development not been in the room. Patricia Marsh sat in the gallery behind them. I sat at the plaintiff's table with Helena. I had Renee with me in the gallery. I had my mother Joyce. I did not look at Derek. I looked at the deed. Helena had printed paragraph 7 of page 4 on a single sheet of paper, enlarged to 14-point font, and placed it in a clear document sleeve. She set it on the table in front of her, where everyone in the room could see it. Richard Marsh looked at the document sleeve from across the room. He had been looking at it, I realized, the way you look at something you wrote a long time ago that is returned to you in a form you didn't anticipate. The preliminary hearing was procedural. Helena was arguing for the void of the eviction proceeding, pending the covenant breach claim. Clifton Webb was arguing that the covenant was inapplicable to an eviction proceeding between spouses. Judge Causey listened to both arguments with the expression she wore for everything. Then she picked up the deed. She read paragraph 7, not quickly, carefully, the way judges read things that matter. Her eyes moved across the language, with the particular attention of someone trained to extract precise meaning from precise words. The courtroom was very quiet. Judge Causey set the deed down. She looked at Clifton Webb. "Counselor," she said, "the covenant in paragraph 7 uses the phrase any action to remove, displace, or restrict the occupancy rights of an immediate family member. Is your position that a spouse is not an immediate family member, under the standard legal definition?" Clifton Webb said, "Your Honor, the covenant was drafted in the context of family property succession, not marital rights." "I didn't ask about context," Judge Causey said. "I asked about the language. Is a spouse an immediate family member?" A pause. "In the general legal definition, yes," Clifton Webb said. "Then the eviction proceeding, as filed, constitutes the action described in paragraph 7, Judge Causey said, which triggers the accelerated repayment provision." She looked at the deed again. "And renders the deed transfer voidable at the grantor's election." She looked at Richard Marsh. "Mr. Marsh, you are the grantor. This covenant operates at your election. Are you aware of that?" Richard Marsh's jaw moved. Clifton Webb leaned over and said something quietly to his client. Richard said, "I was not aware that the covenant would be triggered in this manner." "The covenant," Judge Causey said, in the tone of a woman who has read 30 years of deeds and knows exactly what she's looking at, "says what it says." She set it down. "The eviction proceeding is stayed, pending resolution of the covenant breach claim," she said. "The accelerated repayment provision is triggered as of the date of the eviction filing. The parties will return in 60 days with a proposed resolution, or this court will schedule a full evidentiary hearing on the breach claim and the marital property claim simultaneously." She looked at the room. "Is there anything else?" Clifton Webb started to speak. "Counselor," Judge Causey said, and there was something in her tone that stopped him. "I have read this deed. I have read paragraph 7. I would encourage you to have a very thorough conversation with your client about the position he is in before the next hearing." Patricia Marsh, in the gallery, had both hands on the edge of the wooden railing in front of her. Her knuckles were the color of old chalk. Part 6. The Final Consequence. The 60 days between the preliminary hearing and the follow-up hearing were among the most active 60 days of the legal proceedings, happening almost entirely outside the courtroom. I want to walk you through what the Marsh family discovered, in those 60 days, about the position the covenant had put them in. The accelerated repayment provision required Richard to be repaid the $60,000 gift immediately upon the breach trigger. $60,000 plus statutory interest calculated from the date of the original transfer in 2017 came to approximately $73,000. That was the immediate financial exposure. But the voidable deed provision was the larger problem. If Richard exercised his election to void the deed transfer, the house returned to Richard, not to Derek and Caroline as a marital asset. To Richard. The mortgage, which Derek had been paying, had approximately $240,000 remaining on it. If the deed was voided, the mortgage obligation became legally complicated in ways that Clifton Webb had apparently not fully modeled when he drafted the original document. Richard voiding his own deed gift would effectively create a property ownership dispute between Richard and the mortgage lender, a situation that no one in the transaction had anticipated because the covenant had been drafted as a protective measure, not as a liability. In short, the weapon Richard had built to protect himself had turned itself around. Exercising the nuclear option would create a nuclear problem for Richard. Not exercising it meant the covenant breach stood documented, the accelerated repayment was due, and the marital property claim, which Helena had filed simultaneously, gave me legal standing to claim my share of the home's equity as a marital asset, regardless of the title situation. The home had appreciated significantly since 2017. Its current market value was approximately $640,000. With the remaining mortgage of $240,000, the equity was approximately $400,000. My marital share of that equity, 50%, was $200,000. Richard Marsh was looking at a choice between voiding the deed and creating a mortgage nightmare that would tie up the property in litigation for years, or settling the marital property claim and paying me $200,000 in equity, plus the triggered $60,000 repayment, or fighting the covenant breach in a full evidentiary hearing where the central exhibit was a document his own attorney had drafted, and where the central fact was that his family had served eviction papers on a woman in active labor. Helena presented this analysis to Clifton Webb in a meeting I was not present for, but that Helena described to me afterward with the specific satisfaction of someone who has spent a career preparing for moments like this one. She said Clifton Webb read the analysis, set it down, looked at the window for a moment and said, "I'll speak to my client." He spoke to his client. The settlement was reached in March of 2023, 5 months after the eviction papers had been served at my front door. The terms: the eviction proceeding was voluntarily dismissed with prejudice. I received $200,000 in settlement of my marital property equity claim, paid from the Marsh family's personal accounts within 30 days. The accelerated repayment of $73,000 was waived as part of the settlement. Helena had offered this as a concession in exchange for a faster resolution and a higher equity payment. A trade that made mathematical sense for both parties. Derek and I would proceed with divorce proceedings, in which the house would be sold, and the proceeds split, minus the $200,000 already paid, according to the standard equitable distribution formula under North Carolina law. Richard Marsh did not speak to me directly at any point during the proceedings. At the settlement conference, he sat across a conference table from Helena and me and looked at a point approximately 3 feet above my head throughout the conversation, which I understood as the specific dignity management of a man who cannot apologize and will not perform the admission that apology requires. I did not need his apology, I needed his signature. He signed. The divorce was finalized in August of 2023. I kept the Marsh name through the finalization because the legal documents all referenced it, and changing it mid-proceeding would have created administrative confusion that Helena advised against. As of September of 2023, I returned to Caroline Sutton. Hazel is 14 months old now. She has been walking since 11 months, which my mother Joyce says is very early, and which I tell her is exactly what I expected from a child who demonstrated, before she was even born, an impatience with waiting for things to resolve. I returned to Hensley and Pruitt in January of this year, part-time initially, full-time now. My colleagues were, without exception, the people I needed them to be during the hardest months, covering my work, saving my position, and asking no questions about what had happened, except the ones I wanted to answer. The $200,000 is in an account I opened in Hazel's name and my own. It will fund her education, her start in life, the head start that every child deserves, and that I intend to ensure she has, regardless of what else does or does not happen around her. I think about the deed sometimes. Paragraph 7, page 4. The covenant that Clifton Webb drafted to protect Richard Marsh's investment, worded broadly enough to protect me too. The retained interest clause that Richard had designed as a leash on his son's property decisions, and that became instead the document that gave me standing to fight. I think about Richard Marsh, 40 years of strategic property transactions, always several moves ahead, building protections into every document he touched, and building into this one, a protection for the daughter-in-law he had never valued, and the grandchild whose birth he had used as operational timing for a displacement he'd been planning for months. He protected me, not intentionally, not graciously, not in any way that reflects anything other than the self-serving attention to documentation that had served him for 4 decades. But the document said what it said, and I read every word. I picked up my own hospital bag that morning. I walked past the attorney in the gray suit. I walked past my husband who had stepped aside. I did not sign anything, and I went and had my daughter. The rest was just paperwork. And paperwork, as it turns out, is something I know how to read.